Good evening and welcome to a Saturday night of the Alan Osborne Show. We're going to go over the November 28th, 2023 meeting. And what I'm about to show you is about the ugliest corruption and the biggest lies. And it shows you that this BCC doesn't know who's on first or what's on second. And they're being driven by Clay's lies, Mac's lies, and this attorney's lies. Steve Hall, you got up there and lied. And I'll tell you exactly why when you watch this video. Eyes wide open, people. Look at this. This is our government, and this is unacceptable. It's election year. It's pink slip time. So without a doubt, I'm going to go through this. This is the hearing on the Moxie Hotel in Sandestin. Fred Tricker's about to speak in public comment after a presentation's been made about this hotel. So here we go.
Then we will take, if there's no motions at this time, we'll take public comment. Mr. Tricker.
Mr. Atkinson,
this is where Shipman and some others have directed Tony Anderson to try to put the hit on and try to intimidate Fred not to talk as a citizen or as the representative of South Walton Community Council. And Fred very politely is going to try to tell them, hey, you just uploaded stuff on the county website about this project yesterday that's key to its approval. And nobody got to review it, the public or people before the planning board who would have been speaking against it. He's trying to tell them you can't do that. So watch Tony's hit, and then after Fred survives that, then Clay tries to tell him, no, there's no new information when Fred just said it was uploaded to the county website yesterday, November 27th. So listen to Mr. Tricker.
Mr. Tricker is still a member of the Planning Commission, is that correct?
To my knowledge, yes, sir.
Is this some kind of conflict?
Mr. Tricker, obviously I'll have Mr. Tricker put on the record. You did hear this project as a member of the Planning Commission? No. You did not? It's changed. It's changed since we heard it. But you heard... There's information that was put out yesterday on the public record that I've never seen. Well, Mr. Tricker, the point is,
Let's make that clear. Fred's telling Clay, look, I'm a planning board member, and I just saw information that I've never seen about this project, and I saw it right here at final approval. Continue, Fred.
on the Planning Commission when this project was heard. Yes, sir. So I'll say what I always do when a Planning Commission member wants to wander up here and give their comments. They're members of the public too, they're citizens.
Right.
I do not believe it is good course or prudence for somebody who votes on the Planning Commission to then get up and offer opinions about the project they've already voted on, especially in a quasi-judicial proceeding, because it does give the appearance, if they're speaking for or against it, that their vote on the planning board may have been compromised. So I would instruct the board, if Mr. Tricker chooses to do it, it is something that does pose an issue for the county. But he's a citizen. If he wants to stand up here and speak, he has the opportunity to do so. Thank you. My admonishment to the board is that you cannot give his opinion any more.
So Clay's going to sit here and browbeat the board. But here's what you need to know first. All this is about Sandestin, and guess who's conflicted on Sandestin? Clay. I'm going to make a separate video where Clay talks about that with his own words. But anyway, so just listen to this bullshit go down.
Or less weight than any other citizen merely because he serves on the planning board. If he offers testimony to you today, because this is a quasi-judicial proceeding, that he asserts is based on his knowledge of this from his time on the planning board, then I do believe we're going to have a problem, and he should not do so. He should be giving public comment directly as a member of the public. Yes, sir, Mr.
Well, then I have a conflict.
How's that?
Mr. Trigger is my appointee, who I do value his opinion being a board member.
Well, you can.
I don't recognize it as a citizen as much as I do as his board member.
My admonishment still stands, Commissioner McCormick. Your individual planning board members do not get to give opinions to this board. That's not how it works. The local planning agency is the planning commission, so their board opinion is the opinion you have to rely on. What we cannot ever get into a quasi-judicial proceeding is this.
Well,
And I'm not looking back at how you voted one way or the other, Mr. Tricker, but if Mr. Tricker voted for it, shows up today and says, I'd change my opinion. You can't consider that as changing how the planning board's action was, because he had to do it within the scope of the hearing. So you're welcome to value his opinion in whatever form you see fit, but he is giving this to you as a citizen, not as a member of the Walton County Planning Commission.
Correct.
His statements were as part of the record in that planning commission meeting.
and the point I'm trying to make is I do concur that as a board member, he should not give testimony. That's me, how I feel.
Yeah.
The problem is, how am I going to receive this? I cannot sit here and whatever he says, I cannot distinguish between what's him and a
That is why it is in the best
Because he's
interest
my
of planning board
appointee.
members not to present to the Board of County Commissioners.
He's my appointee, and that's how I see him as a board member. If he gets up here as a citizen, I'm just saying I'm not going to be able to separate the two, because I think of him more as for me, anything he says is going to become as a board member.
That's why I advise against it and find it to be poor practice for members of advisory boards who've already had an issue to come present before this board. But there is not a firm policy that prohibits it.
Well, I'm just saying,
Of course, Mr. Smith and his client may wish to assert that you're required to recuse yourself based on your statements. That will be all I can say. If you're saying that you cannot accord his testimony the same as you would any other citizen, then they have the right under 286.012 to assert that there is fundamental bias or prejudice in the proceeding.
well, I think
You got to be a judge here, and as a judge, your job is to say, I may like Mr. Tricker, I may know Mr. Tricker, but you're just giving your comments as Fred Tricker's citizen, not as a board member, as hard as it may be.
Well, sounds like, Mr. Smith, you need to tell us if Commissioner McCormick's got to recuse himself or not.
Excuse me, could I just add something? As I'm not just representing myself as a citizen, I'm also representing South Walton Community Council. So it's not just my opinion.
it doesn't change my perspective. I'm still hearing it coming from a board.
And I'm not an expert witness. I mean, there's nothing I tell you that's going to be, in terms of a quasi-judicial hearing, it's not going to be material.
So if Mr. Tricker's stipulating that nothing he says is material for the purposes of determining competent substantial evidence, he's just offering public comment, but you can't use it in your decision-making process. That resolves the entire process.
Thank you.
Tricker.
Thank you.
There you go.
Okay.
So we don't need to go to Mr. Smith?
We'll let him say whatever he wants. Mr. Smith can make his decisions afterwards, but he's acknowledging that nothing.
I hope everybody just caught that Clay told the commission that you can hear public comments, but you can't use them in the decision-making process. Total bullshit. They're up there to represent the people and to hear how it impacts the community. Continue, Fred.
Nothing that's said can be used for or against the project. So at this point, you have competent substantial evidence until someone presents otherwise, and he's acknowledging his will not satisfy that standard.
Will you hold that in abeyance, Mr. Smith?
Yes, sir.
Okay. Proceed, Mr. Tricker.
Thank you. Boy, that took a while.
Everything takes a while.
Well, I've never been in a situation before. This is the first time around for me. I just want to make sure you nor I or anybody steps in line it's going to hurt somebody.
I understand. And I think,
Abundance of caution, that's all.
yeah, so
Now, Boots McCormick just told us all that he's worried that somebody might step across the line and hurt somebody. Really, Boots? I'll point this out to you in a little bit. Who's stepping across the line?
first of all, I want to make it clear that SWCC has nothing against this project. It's probably a good project. So there's no objections or concerns there at all.
Bill, could I interrupt you just a second?
Yes,
and Fred and I've known each other for several years, and we have our love.
Here comes Tony again. Everybody's flushed it out, but Tony is unhappy and has probably got a phone text from Shipman or some other piece of shit that he needs to hurry up and try to shut Fred down again. So go ahead, Fred, and deal with Tony. Come on, phony Tony, just sit there.
For golf in common, but I'm not trying to discredit Fred at all. And the fact that he said he was not at the meeting eases my fears. I just want to make sure Fred doesn't get in trouble and we don't get in trouble.
You're not going to get in trouble. I've recommended against Mr. Tricker in this scenario as a.
Somehow Tony is worried about who's going to get in trouble. You know who's going to get in trouble, Tony? You guys, if you don't hold the staff who's lying to you and the laws who are being broken accountable. Tony, you're the ones that ought to be in trouble, and some key staff people.
So would any planning commission member doing this, but I recognize his ability to speak as a member of the public. Mr. Tricker was president of the planning board.
Oh, was he?
He was saying there's information that's come up that's new, so he's asserting to you that he believes.
Yeah, so Fred doesn't need to be an expert for this. Fred's on the board. He just said the county uploaded all these files that even Fred never saw yesterday. So he doesn't need to give an expert. There's competent proof that it's just been admitted the files were uploaded yesterday and they have stuff that Fred's never seen. He doesn't need to be an expert. He's pointing out they have a procedural violation and they shouldn't proceed. But Clay doesn't want to hear that.
To pass the consent agenda.
So moved.
Sorry, commercial ruined it. I'll have to catch y'all back up.
And so I think there's a process issue here where people haven't had due process. They have not had an opportunity to look at this new evidence. So that's a question that I have. It's a legal question. And the other question...
Let's get a ruling on that part.
As I understand it, the matter passed the planning commission with an understanding that it would pass the planning board with our approval, contingent on no new information being received by attorney Steve Hall during his meeting with Alan Osborne.
Okay. Clay just admitted it. It's only got a condition of approval if Alan doesn't produce any information. Well, Alan did produce information. You will hear Mac throughout this testimony say, and Steve, that there's been no information presented since the 2017 NOPC ordinance. It was 2017-12. It was recorded in November of 2017. Now, here's what you need to know as you listen to all this bullshit. Listen to Steve and Mac swear there's no information, and listen to Clay talk about how there's no proof or competent information. So here's what my proof is, and here's how simple it is for people like Boots. They're telling you that there's no new information since 2017. The county accepted from its own hired expert a Sandestin report in 2018. Strangely enough, 2018 is after 2017. Secondly, the Florida Board of Engineers, the highest review authority in Florida, reviewed Dr. Harper's findings on the county and took the argument of the county that Dr. Harper was incorrect. And it's the same one that was given at this Moxie Hotel briefing. The Florida Board of Engineers, a PhD, said he reviewed the county's response and the county was wrong, that the county's been using the wrong drainage standards at least since 2007 when it was put on notice. So keep all that in mind, that Clay doesn't think that the engineer the county accepted his final report in 2018 and the final conclusive findings of the Florida Board of Professional Engineers that the county had applied the wrong standard to Sandestin is not competent proof. So let's continue.
Now, Mr. Speaking in this meeting, during that meeting with Alan Osborne that Mr. Smith just presented?
You got watch out, Jeff Fred.
Oh, sorry.
Steve snuck up on
He wants my microphone. It's all yours.
Mr. Chairman, Steve Hall, attorney for the land use component of the planning department. I took the opportunity, being the attorney who, as I described it, probably the only one in several counties that wasn't involved at some point in the Sandestin debate. Mr. Osborne provided sworn testimony there that he had new information that had not been considered before. And
Remember, Steve just told him what I said. I had new information that not had been formally considered before on Sandestin's compliance. Mac says 2017, everything is compliant and there's been no competent evidence offered. Steve Hall, Mac, and the whole county commission have Dr. Harper's report. Hell, it's in the county record and it's in the documents that were uploaded the day before that Fred's talking about. And then there's the Florida Board of Engineer findings, including there's letters out there of Greg Graham the county possesses, says he agrees with Dr. Harper calculations, and procedurally they need to change what they have in writing. So proceed, Steve. Proceed to Steve to be a lawyer and tell the board that something that you got in 2018 and something that was found out in 2020, that somehow Matt Carpenter reviewed that by November of 2017. That's what bullshit looks like, folks. So proceed on, Steve.
that he wanted to present that to the planning department, to the planning commission. And he then referred to a number of documents and made some claims in relation to.
Yes, a number of documents was Dr. Harper's final accepted report and the Florida Board of Professional Engineers report, which I offered to go over in detail, but they just wanted to discuss. I get 3 minutes, everybody else gets 30. But yes, I told him the documents. Once again, continue, Steve.
Specifically 2017-12, the ordinance that David was talking to you about. So I volunteered before the vote to sit with Mr. Osborne because it was going very quickly, and I couldn't catch all that he was trying to present. So I said I would sit down with him. Mr. Tricker and I sat down with him and had coffee and hot chocolate, and we talked for a couple hours. And he explained his position. I then took everything that I had in my notes, carried it back to both the planning staff and to the applicant, as we do with all comments that we receive on any open application. We share it around and say, hey, this is now in the record. Can you respond to these points?
This is now in the record. Can you respond to these points? The county has had Dr. Harper's report since the BCC accepted it in 2018. It was after 2017. And the county's in possession of the Florida Board of Engineers report because they responded to it. And we're told, nope, you were wrong. Plus, I gave them a copy. Continue, Steve.
The way I see the process has progressed is I committed to an interview to get more detail on the presentation that Mr. Osborne did in front of the Planning Commission, fulfilled that meeting, the results of that meeting back to staff and the applicant, asked them to respond. Tell me with all your knowledge and background, because as you've seen, we have 12 notebooks here behind me, which constitutes the physical record of the documentation that we've had on this project. With everything that you guys know from your experience, is this new? Is this something that hasn't been raised before? Is this something that the department needs to reconsider? I think what you had tonight from Mr. Smith was his response to those comments that were submitted.
Let me walk you back one step just to make sure we put a pin in that folder. You did not, based on your review of that material and your discussion with staff, you and staff did not determine that you were presenting new information.
That's correct.
So that would.
Listen, if you mean new as in new, it's new information that the staff has not received and reviewed. In 2017, Mac will go on to say that at that NOPC, they reviewed open space because it was out of compliance. He gets asked, did you review drainage? No. So he didn't review drainage in 2017, yet Mac went to that hearing possessing documents from 2007, 2010, and 2014 from the state telling him that they were in non-compliance if they didn't have these standards met or they had to have hearings. So continue on as we twist this.
Not affect the planning board's recommendation for approval.
That's correct.
And recommendation at the
Listen, folks, he just said that there's nothing out there that would recommend the staff not approve this project. It's not up to the staff because Florida statute 380.06 says if a DRI is in substantial noncompliance and not following the drainage basic standards of substantial noncompliance, they can't issue any services. And this hotel, now Clay will lie, say it meets everything in the LDC. No, it didn't. It's over 50 feet, so it needs the DRI. And if it wants to use a DRI privilege of building over 50 feet, then the whole DRI must be in compliance. And I'm trying to make that simple. So Clay, tell your lies.
This was in compliance with drainage, traffic, and these other issues.
That's correct.
And what I would say is, based on what I've heard, I don't believe there's a due process issue. I don't see an adversely affected party saying they've been deprived of an opportunity of notice and an opportunity to be heard, which is due process. Secondly, I would note that if it was already found in compliance, they met, they reviewed these. Mr. Osborne, as a citizen, was given that opportunity. That was all made part of the planning staff's record. I think the applicant has a due process right. The applicant's due process rights to respond to what's brought up against him. If this is not the introduction of different evidence, Mr. Alden said he believes it's his interpretation or response. I don't believe it's a due process issue.
So let's think about that. The applicant has a right to respond. But why isn't it a due process issue for everybody else if they're continuing to let people do stuff that the law specifically prohibits? Look, this is not an engineering question. It's a procedural question because there's a lot of engineering techniques out there, and truthfully, this is a good project. But because he wants to build it above 50 feet, Clay's statement is it meets everything in the LDC. It's probably the best drainage plan ever introduced in Sandestin, and worse, it's proof that if the county had made people building in Sandestin, this guy just proved you can build a hotel and retain all your water. So why couldn't the county make everybody else? This guy just proved my point of 18 years, that adopting the correct standard and accepting what it is, you don't even have to adopt it. You got to accept it. Everybody else in the state says it's written, but it's good for everybody. Because look, these people right here were willing to meet the drainage standard. But unfortunately, the whole DRI is out of compliance, and the county, by law, should not have accepted his application. It is new information because Mac goes on to state that nobody's reviewed anything on drainage because Mac don't want to accept that anybody can accuse it of being out of compliance. But the county's own report and the state accuses of it, and proof has been accepted, and if it's an engineering issue, it's been reviewed at the highest authority in the state, the Florida Board of Professional Engineers, and they've rendered it that the county is wrong. Continue.
I think what the applicant is in line with what you hear on any major development application where public comments or citizen comments have been received. You need to address these in front of the board. And that's, I believe, was the genesis of his analysis and resulted in what he presented to you tonight.
I think that's both Mr. Hall and I telling you it's not a due process issue.
Any questions for Mr. Hall? Continue, Mr. Tricker.
Thank you. Okay, well, I'm not an expert witness, but I think Dr. Harper was brought in as an expert y'all paid him a lot of money to come in and look at this situation. And my understanding is that his assertion that the 6.7 standard was.
For you guys that haven't connected the dots, Mac and them just said they reviewed everything. And here Fred is even naming the report they hadn't done anything with. Dr. Harper's report. It was adopted in November of 2018, a year after Mac adopted the 2017-12 ordinance. Folks, this is easy math. All you got to do is be able to add years. Continue, Fred.
Was for treatment. It wasn't just retention, it was for treatment. And that's like opposite to what Mr. Smith said. So I'm not positive about that, but I'm pretty sure. And when you brought him back in to do a further study, a second study, that was to look at how you would fix the problem of meeting the 6.7-inch standard. And the cost of that, as I recall, was something like $11 million. Do you remember that?
That sounds about right.
I mean,
Commissioner Anderson, remember?
I don't remember what the number was.
I mean, it was a big number, so that spooked everybody. We've had a lot of discussions about nailing it down as to what the standard actually is. And it's been discussed many times. And I recall a BCC meeting. Mike Barker had just been elected a commissioner, and he made a statement that he felt like he's like the rest of us. You know, none of us really know for sure what the standard should be, but he felt like we should get to the bottom of it and get it resolved once and for all. I don't think that's ever been done. You know, tonight is probably the first time that I've heard that kind of detail about what the standard is and what it means. And Mr. Smith went at it a little bit differently. He wasn't arguing against the 6.7-inch standard as not being applicable. He was basically saying, well, what they provided meets that standard. So that's a little different argument. But I think it still behooves the BCC to look into this and determine once and for all if the 6.7 standard is the applicable standard, then the Sandestin DRI is not in compliance. And I think that has to be evaluated, and I don't think it's up to us. I think it takes somebody, it's a legal question, and I think you have to have somebody independent that'll review it, look at it, and give us a final determination. Because I think there's been so much conflicting information over the years that I don't think any of us really knows for sure where the truth is. We don't know. I certainly don't know. I mean, I sat through the meeting with Alan and Mr. Hall, and I followed the conversation, but in no way could I follow the arguments. This stuff is complicated. It's really complicated. I couldn't do it. That's why I'm not.
Listen to what's complicated. Mac and Steve and Clay say there's no new information since 2017 when they found it in compliance, even though they didn't review the stormwater and they had information. Well, now the county's paid hundreds of thousands of dollars and accepted a expert's report, just what they're going to propose to do all over again. But there's no higher level to take it to, because I turned that report into the Florida Board of Engineers, and they went down there to say Dr. Harper was wrong. And that board said, those PhDs said, no, he's correct. You can use a new standard and pick a better standard or more reasonable standards, but you haven't been through the procedures. And you have to admit you're in non-compliance before you can get there. And see, that, folks, is the tragedy, is this has been covered up since at least they've been on formal notice since 2007. And Mac and Clay and Tony Corman and code enforcement, they all have been involved in it. And Danny Glidewell helped cover it up. Yes, he did. He does not want that standard to be found. He almost jumped out of his seat in this meeting because he thought that guy approved it for all of Sandestin, that his drainage worked, and he was just talking about the Moxie, and the air went out of Danny's lungs. So continue, Fred.
Not even trying to imply that I understand any of this stuff. It's too complex. So
I will say, I think it's more of an engineering issue than it is a legal issue.
well,
And that's my
No, it's been legally lied about, Danny.
You know, I think Mr. Smith's argument was that he provided a system that actually is better than the 6.7 inch standard. So that's not the issue. The issue is whether the 6.7 inch standard is the standard and whether it's for attenuation or retention.
But I think, and I'm sorry, Commissioner, but I think Mr. Smith, and you can correct me if I'm wrong, but I think Mr. Smith's assertion is that the standard that we're applying now is a higher standard than what the 1976.
No, he's saying his project is, just that hotel.
13.4.
Danny, that's wrong.
For this project, yes, sir.
For this project, not for the overall DR.
Well, then maybe this is a question for Mr. Carpenter, but is that what we're applying to the
No,
rest of it? No? Then why are we applying to the rest of
The
it?
84.
What's the 84 standard?
It's still higher.
I believe this is a legal question that I don't think you can resolve with stormwater.
Well, respectfully, I'll say to the board, I think it's not a legal question. It comes down to an understanding of.
Clay wants to say a legal question is not enforcement of the law. Are you shitting me, pal? This is crazy. Yes, Clay, you're not informing the board that they can't proceed on. Clay, you know about 386. You're talking about Sandestin, and you, sir, have a self-declared conflict when you were hired to advise the BCC because you represented the developer. It would probably mean that you lied, Clay, and you're sitting there advising them on this issue. You're in conflict, Clay.
Of the stormwater standards, because we're talking about stormwater. Mr. Smith did a very good job of discussing what are you talking about? Is it quality? Runoff? What are we talking about? That's what you got to decide. Mr. Smith has presented his opinion. I do not believe this board needs to reach the overall DRI issue tonight because regardless.
You don't believe the board needs to reach the overall DRI issue. Clay, the board has a legal obligation, if it's in non-compliance, to determine that because they're not supposed to issue any more development orders, especially a major one that exceeds the LDC height standards if the whole DRI is non-compliant. How can you give that advice, Clay?
So what standard? He's saying, one, he's not using the lakes, he's not using the Sandestin stormwater systems, and he exceeds all standards that would be applicable. So for this project, I want to go ahead and put a pin on that issue. I don't think you have to get there. I don't disagree with Mr. Tricker that getting a definitive answer on this would be helpful. And I think it's necessary at some point to put an end to this. And I think every member of this board has heard me say that, by the way. Respectfully, Mr. Tricker and I disagree on the legal issue. I think Mr. Alford would concur. We as attorneys can read what was written, but what is not written in any one of these documents is what the 1976 standard was specifically referring to. Now, Mr. Smith has given.
Listen, all that's been settled by a court agreement in 1984. Clay knows this. It is a legal issue. Why are you not advising the BCC of what these findings are. Why are Mac and them saying there's no new information? Because Boots couldn't understand that Florida Board of Engineers report if he had to. Tony doesn't want to. Donna's not sure. What's going on? Brad is sick this night. Danny's crapping his pants because here this issue comes that he never dealt with. And Clay's trying to do the cover up for the good old boys. The administrator can't act because they're trying to lynch him. This is what I call the shit show.
Given us his opinion of why it meant quality versus not quality, why it wouldn't be one, why it's one and clearly not the other. To me, that answer for the board and for you, Mr. Tricker, is best addressed by a stormwater engineer with experience in how the
is best addressed by a stormwater engineer. Harvey Harper, who they accepted his report in 2018. He made a preliminary in 2015. Mac refused to review it in 2017 because he said it was still a draft. Harvey Harper is one of the foremost experts in the state. Since been involved in stormwater and everything at the UCF level and all that for the state education system, the Board of Engineers. And the county picked him last time. Clay wants to repeat the process, even though Harper's findings were revalidated by the Board of Engineers. This is a definition of insanity. That's what this is.
These standards were applied from 74 forward. So the pre-76 standard into 84, and I'm not saying Mr. Smith's not qualified to do it. I'm saying he's here on behalf of an applicant. So he's not going to be the county's representative. But certainly I think that is how you get that answer, because there is a second component, and there are multiple layers of this, but the second component ultimately becomes if it's not in compliance, and somebody tells us that, it's not just what is.
I've been telling you that. And you settled over that issue and then kept doing it. You've already paid out on that issue in 2016 of what you were doing. And now you've done worse. You have more competent proof that it's non-compliant besides the state letters, and you're not taking action again. And all the taxpayers are paying millions to cover it up. And the bay water quality is suffering, and I understand some people just sued the county because they're catching infections in the bay.
Is the fix, but what are the fixes? Are they remedial? Are they prospective? Are they retroactive? What are they? And how can those be addressed? Those are things that have to be considered. But broadly for tonight, I would say none of that goes into play on this specific project, and this applicant is entitled to have their project based on what they're submitting. Now, if they were trying to say, hey, we want the 76, we want the 84 standard versus the 76, that will be squarely in front of you. They're saying they met and exceed those. Unless there's evidence that they don't, I think they have ticked that box.
Commissioner McCormick?
Yes, I concur that there's time to put this issue to bed, but I don't think that applies to this project. I think that should be a separate conversation altogether. It doesn't come in the.
This isn't poor Boots' fault. Clay should be stopping him because Boots is trying to make an individual project that's relying on the complete compliance of Sandestin, and this project needs to exceed 50 feet, and he doesn't understand the tie that this project doesn't meet the LDC standard without Sandestin's exception, and Sandestin must be compliant. But Clay, it's not your fault, Boots. Clay never tells you. Mac never tells you. Steve Hall never tells you. This is quasi-judicial, and they are sworn.
To play on this project for this fact. No matter which standard we use, or at the end of the day, if we look into this supersedes above even either one of the two.
No, it doesn't supersede anything. You're saying that what they did exceeds both standards, not supersedes. And besides that, Boots, you still don't understand the law because Clay and them aren't stopping you. Mac's not stopping you. Your county engineers aren't stopping you and telling you this. They're letting you guys get in trouble, and they're using you guys as cover to break the law. and spend tax money to cover up the lies.
Formula you use. And with that said, since they're not adding to the problem, they're keeping their problem. I just don't see where the answer to that question, one way or the other, affects this project.
The only thing that has an impact on this project is whether the 6.7 inch standard is attenuation or retention. And it does have an impact.
So Fred gets it.
So you're talking about, I'm not an expert on this, but you're talking about even at the highest standard of the two choices, you're looking at probably what, a 25-year to a 50-year storm plan.
Yeah,
They've gone beyond that. That's the point I'm trying to make here. No matter which one of these standards we use, I feel they have gone beyond, and it's not applicable to this because they're not putting this water into any other system. It's self-contained. And I just don't see, no matter which side the fence you're on, how this applies to this problem.
Okay, I'm not a stormwater engineer, but his analysis was based on the 6.7 inches being a retention standard. And I don't think that's what the Harper report said.
Okay.
And there's a big difference in how that affects the analysis.
I don't see it that way if the standard that they're using is higher.
We can let Mr. Smith address. I think he's going to tell you he's retaining all of it, so that negates it, is what the presentation was.
He's probably got 3 pages of notes already. Just one other thing, if I may, regarding the legal question. I think it is a legal question, and I'll tell you why. Is because the 6.7 inch standard that Mr. Osborne believes is the one that is actually still in effect.
And that's what the state and everybody else believes, but the county.
They've been using the Land Development Code standard, which is a 1/2 inch. And for everything
they've been using 90% less.
Since they started doing that,
10% compliance.
I've been meeting. If the 6.7 standard is the one that's still in effect, the DRI is not in compliance. And that is something that has to be determined for the future projects.
Well, Ms. Tricker, I think you would agree the first question is, what is the proper standard?
You've been told,
Absolutely.
Clay.
I think
You've adopted it. Read your ordinance.
Determined, planning, legal, any of these other areas being required to weigh in is premature. I think it is a simple analysis starting at a stormwater.
A simple analysis they've been trying to get to since 2007, but they won't because they lose.
Down to legal sometime down the road.
The staff lied. We all paid as taxpayers.
The question deals with stormwater and the standards.
Yeah, so as far as this application is concerned, I don't, in my heart, I don't believe it matters. But I think the whole DRI question is one that you all need to address.
Well, let me say this. I've been saying since 2017 we need to get this fixed. One way or the other, we need to know, because frankly, someone like Mr. Smith shouldn't have to do this to get a project approved. There should be some certainty in the process, and the only way for that to happen is for this board to say what the standard is, period. One way or the other. I agree with you 100%. Been saying that for a long time, but I do agree that for this project, it seems like Mr. Smith, from what he showed on his graphs, they're far exceeding either retention or water quality. Either one. Is that
Dan is too dumb
Smith?
to understand Fred.
But
Fred said it doesn't matter about this project. It matters about the whole
we
thing.
need to get this fixed one way or the other. There are a couple of things I swore I would see before I died. One would be the end of proportional fair share, which we may be coming to. And the other one is this problem resolved. We'll see. But I agree with you that we need to get it fixed.
Thank you. Thanks very much.
Any other public comment? Any
Remember,
other
this
public
is all
comment?
sworn testimony.
Yes, ma'am.
I gave you only 2 minutes. I didn't mean to be here this long. I thought y'all were going to do the officers right after the meeting. But I do have a question. If a DRI is in question, which it is,
Suzanne
the
totally
Professional
gets
Board
it.
of Engineering said Dr. Harper was right. If the DRI is in question, can you legally approve another project? Because if the DRI is out of compliance, you cannot approve another project. So I think that's something y'all have really got to come to grips with. Every time we do something, we say, well, the DRI's out, but we got to get the DRI fixed. And I have an email, Danny, that you, and I didn't bring it up here, but I should have, that came to you from an engineer 2 years ago in 2021, to you and Tony. And it had a whole attachment to it about the 76 standards and everything. And it got forwarded to Mr. Osborne. And I've had it for a long time. But if the DRI is out of compliance today, and y'all have been put on notice it's out of compliance today, and you've been put on notice 4 years ago, 5 years ago, all this time, and in court, when they said part of the settlement was you had to go to the 84, if you keep approving stuff, I'm afraid y'all are going to be in a mess. Because every time this board approves something, if y'all hadn't taken the time to really prove whether the DRI is in or out, and you keep allowing building to go on, and I think this building is absolutely magnificent. I think it'd be one of the greatest things that ever hit down here. The architect's wonderful, and I have the utmost respect for you. So this has nothing to do with you, because I know that water can be retained. It can be detained and retained and whatever tained on that property.
Suzanne gets
I
it.
know
They
can
could
be
all
done
meet the
because
standard,
I
but
was
the
all
county
for the
won't
Hampton
make them.
Inn across the street from Edgewater, because I was told they could retain and detain all their water. So I was the only one that supported it. Grand Dunes and all them fought it, but I supported it. But I think y'all are backing yourself into a corner every time you keep approving something in that DRI, because you really, not one of you can stand up in court and say, I believe that DRI was in compliance, if you're asked.
With all due respect, Ms. Harrison, if
It's Harris.
Ms. Harris,
That's okay.
if the only thing that appears that to
Boots is
be
crap in
maybe
this
out of
thing.
compliance is the stormwater plan. All right?
And
Can't
traffic.
approve anything if their stormwater plan's out.
Okay.
All
Okay.
future projects stop.
All right. Not, but it doesn't apply to this.
Yes, sir.
If they were showing us a plan where they're going to use the existing system out there, well, that's my standpoint. I don't see how this particular, no matter what side of the fence applies to this project.
If you're speeding,
Mr. Carpenter,
and the speed limit's 75, and it says if you go over 75, you get a ticket. You're gonna get a ticket.
well, I would have, all y'all, Ms. Harris.
Matt's gonna
y'all need to,
lie.
if you're gonna speak, come up to, because the clerk's gotta get this stuff. And this is a quasi judicial, she's gotta be on
I
it.
mean, everybody's
So if you're
sworn,
gonna
and Danny
speak,
knows
you gotta
it.
come to the mic.
All I'm saying is, if the DRI is out of compliance in any way, stormwater, too many houses, but it's all been about stormwater.
And traffic.
All right, if the stormwater and the DRI makes if the stormwater's out of compliance, the whole DRI is out of compliance. And if the DRI is out of compliance, y'all can't just keep approving projects.
So let me ask a few questions, Mr. Carpenter, that will address that.
Here come the lies.
Mr. Carpenter, you were employed with the county in 2017, correct?
That's correct.
You are familiar with the notice of proposed change filed October 24th, 2016, along with the revisions.
And he'll say
of
no
November 16th,
stormwater
December
review
1st,
was
and December 6th of that
performed.
same year?
Yes, sir.
Were you involved in that project whatsoever?
Marginally.
You've had a chance to review ordinance 2017-12 and revised ordinance 2017-12 that were adopted related to that. Is that correct?
Yes, sir.
Have you had a chance to consult with planning staff officials who were involved with that process?
Yes, I have.
Are some of those persons still on staff today?
They are.
And you've had a chance to consult with them regarding the DRI as it relates to this project, correct?
Sure.
What is your understanding briefly of what revised ordinance 2017-12 did with regard to the DRI and it being in compliance?
It acknowledged, it did not speak to stormwater.
They didn't do nothing. They didn't review it.
The county did not find stormwater.
But they had evidence.
non-compliance.
He
What was
just
found in
ignored it.
non-compliance was the open space. Traffic was evaluated.
They've been
based
ignoring
on
it
the
since
revised open space,
2007
proposal
on notice.
that appeared in this ordinance you just described. The traffic was found to be in compliance. Ordinance 89-9 adopted the settlement agreement and all of the documents related to the settlement agreement, including the assertions made by the applicant where they agreed to increase the size of the bonds, reduce the size of the marina, and adhere to the new state stormwater quality standard, 1725.
And with regard to revised ordinance 2017-12, is the reason we have a revised version of that ordinance because actions were filed with both the Florida Land and Water Adjudicatory Commission and the Circuit Court of Walton County.
That was over digging
challenging
up
the
part of
ordinance
the
being
golf
inconsistent
course.
with the comp
They
plan original.
ignored
Yes, sir.
The
5
revised
competent
ordinance was
letters.
part of a settlement agreement that was reached to resolve those cases.
By all the parties, yes.
And at that time, the county's determinations were there were no non-compliance related to stormwater, correct?
That's correct.
And that's what this board adopted?
That's correct.
Are you aware of any court order or adjudication by a state administrative agency or other body having authority over developments of regional impact or this county that has determined that the Sandestin DRI is in non-compliance on any issue since the 2017 revised ordinance?
Listen, Mac said he didn't review stormwater. Mac had 3 competent letters from state agencies who had authority over the DRI. 2 from the DEO and 2 from the DEO, or 1 from the DEO and 2 from, I'm trying to think of what it was before that, but they had, no, that's right, 2 from the DEO and 1 from the DCA at least. They had 3 competent opinions. They also had their own experts' findings that they hired for stormwater review of the DRI. And then they had the Florida Board of Engineers. Now, Clay, so the DEO is still in charge and is a competent authority. They've never responded to the DEA's things. So Mac and Clay and the planning section of Walton County are in possession of at least 5 sources of information that are considered competent authorities over stormwater, and they're flat refusing to hear it in public. They're ignoring it. They're not submitting it into the record, and they're not considering it in their evaluation because they don't want to, and because the developers and the good old boys, and Mac should be fired. There's been millions of dollars spent to cover up. The Walton County's direct piping water into the bay right now, and we spent millions of dollars in taxpayers because people on staff lied. Folks, that's wrong. That's wrong.
I'm not aware of any.
He's not aware of any.
Your role as the director of planning for Walton County and tasked with representing matters to the local planning agency, would it be your purview to receive such information if it came in?
It would.
And you've not received any
I
of
have
this?
not received any.
So, Commissioners, what I'd
He's not received any information that would indicate that Sandestin DRI stormwater is out of compliance, according to Mac Carpenter. Continue, Mac.
say is you have assertion that the DRI is not in compliance. I understand that is an assertion that is being made. There's a difference between someone asserting that it's not in compliance and a finding that it's not in compliance. I'm going to say very clearly, I don't think it hurts this county at all, and it is my recommendation that we do, at some point, get an independent stormwater engineer. And Mr. Robertson, by the way, and I have had detailed conversations about this over the past month and a half, to bring in someone to try to get us a definitive answer on stormwater with an eye towards any issues that need to be addressed. Because, and Mr. Smith, this is not on your project, so my apologies to you first off, that I'm taking up his time on this. But we know there's stormwater issues all over Miramar Beach and South Walton. So we might as well go ahead and address it wholesale, look at the entire.
Here Clay tries to climb out of the DRI. Now he wants to just kind of review the whole basin in South Walton and not admit we're this multi-billion-dollar largest development in South Walton that directly impacts runoff on the bay, beach, and everywhere. Whether it's in compliance or not, we're just going to skip to Malou over that. God, can't you commissioners see what he is to the county? He's not good for the people.
Drainage basin, and this is part of it. That doesn't mean we're doing it because the DRI is out of compliance.
We're doing it for a smoke screen.
Or some other determination that the DRI is out of compliance post 2017, and there has been litigation. Let's don't kid ourselves. We've gone to court. We went to court in 2017. That's why there's a revised ordinance. There is not a finding by anybody that has authority over this that says this is out of compliance.
The DEO had a finding.
2017 found it's in compliance. Based on that, what I'm telling you is you're to presume compliance until somebody proves in a court of law or otherwise that this is out of compliance.
Meaning we got to sue to make them admit the truth.
If the speed limit's 70 miles an hour and you're driving 75, you're breaking the law. I agree. But if somebody says, man, you blew by 20 cars in a row, speed limit's 70, you must have been going over 75. Well, proving it. The point is they have to. Right now, that's not happened. Until that happens, or until there's proof offered and someone determines it's out of compliance, my recommendation to you is to treat it as in compliance. Otherwise, I believe any applicant seeking a major development order approval that complies with the Land Development Code and Comp Plan in the absence of evidence showing they are not in compliance is going to have a heck of a lawsuit against you under both cert to overturn your decision for a lack of competent substantial evidence and probably under the Burton J. Harris Act. So that's my recommendation on those issues.
Well, may I ask you, separate from this hotel, separate from this that we're looking at right now, can we tonight move forward in some fashion to make sure that we do come to a conclusion on the DRI?
If you allow Mr. Robertson to come back with some discussions he and I have had with some proposals to you at one of your next board meetings before the end of the year, that would be appropriate. It's not on the agenda. I can't let you take action in that situation.
Well, we've done that before.
Well, it's what I'm telling you here is you're in the middle of a quasi-judicial proceeding, and I think we'd be way out of line to do it in the scope.
We basically had a DRI, unannounced DRI hearing in the middle of a quasi-judicial.
Your administrative team to come back with some solutions.
That's why they're not supposed to take applications, so this doesn't happen.
Determine whether that meets its approval.
Okay.
And that is something that you have been working on, correct?
Yes.
It's not. This is not whole cloth new to him.
Right.
This is something he's been addressing.
Thank you. So before the end of the year, you will bring something back, right?
Well, you only have one. I think you only have one official board meeting, right?
Oh, is it December already?
2.
Well, it will be next month. It will be Friday. So, yes, ma'am, it'll be at that meeting in December. I wasn't pinning him down in case we had a special meeting, but that's the intent.
Thank you.
Any other questions or statements? Any other public comment?
I know I gotta come up here, but I don't want to. I wasn't suggesting y'all stop this project. Believe me, I think this is gonna be an asset. I wasn't suggesting you stop this. What I'm telling you is, this has been going on every year for at least 4 or 5 times a year. It's out, it's in, it's out, it's in. Danny, the email that you got is this thick in the back, because you had all the attachments to it. But somebody in your office forwarded it on to Alan Osborne. And so this has been going on forever and ever and ever. And we've got to come to a decision that it is Harper said it's out. This one says it's in. The Board of Engineers said it's out. Whatever. We've got to find a decision before Sandestin. You can't even walk on Sandestin. And we're 5 years, 8 years down the road, and we keep talking about it all the time. Is Sandestin in? Is Sandestin out? Y'all got to figure it out.
Any other comments for the board?
No.
I'm gonna close, or any other public comment? I'm gonna close public comment and give the applicant a rebuttal.
Okay, I'm gonna stop this because it's been so long. But folks, it was a crime today. This is why 38006 tells the county you will not provide any services for planning, because now they've put this applicant in the bad position. But the law's clear. You can't, he's going to need an exception, and Clay says that his project met the all LDC standards anyway. No, it doesn't. It exceeds 50 feet. This is a shit show. They try to say it's complicated. I can teach it to most people in about 30, 40 minutes. Mac and Clay have 5 competent sources of information the county has invested millions to acquire and has been reviewed at the highest state levels. They just simply refuse to report it to the state that Sandestin is substantial non-compliance, because part of it's happened on county land, and there's employees that have been covering it up, and they know it, and they should be fired. And that's the way it was on the Alan Osborne show. A little different format, way long show, but I wanted to narrate it. I don't even know how good this is going to be, but I want to try to explain a meeting without even, just sitting there walking you through the bullshit of Walton County. Folks, this is wrong. This is corruption. This is why we pay such high taxes. There's all kind of this crap going on in our government. And if you want change in DC, you want change at the state, we got to change our underwear down here, because these people don't have the guts to tell the truth. That's all it was for Alan Osborne today. Hard to watch this if you know the truth. It's pretty bad, isn't it? That's the way it was. I'll talk to you guys soon. It's December 2nd, 2023.